What defense in criminal law do you think is the least used by criminal defendants? Only 2% of criminal defendants use the insanity defense. No subject in criminal law has received as much attention and debate as the insanity defense. Questions and debates, in such cases like the 1992 Jeffrey Dahmer case and the insanity tests and types, when the verdict comes in as not guilty by reason of insanity, like the 1993 case of Lorena Bobbitt, faking insanity, sentencing involved, and what happens after sentencing is completed, are all things I will go over to help the public better understand why there is such debate and concern with the insanity defense. The questions and most debated is to what degree of insanity, mental defect, or mental disease renders a person blameless for acts, and what insanity test should be used to determine legal and moral liability. The insanity defense is rarely used by lawyers for minor charges, most often used for murders or other serious felony charges, when evidence is against the defendant and no other defense is available. Those who do use the insanity defense do realize that the insanity plea is not an easy way out. One example of a defendant using the insanity defense is the 1992 Jeffrey Dahmer case, where he was quickly found sane and criminally liable after he had murdered 15 young men and drugged and performed crude lobotomies on some of them in an attempt to craft zombie-like creatures. Dahmer had actually sexually violated some of the corpses and dismembered bodies, storing body parts of his victims in various places, including a heart from a victim he had claimed he was saving for later to eat. In that case, the insanity defense was unsuccessful. There are a few tests used to determine the degree of insanity or mental disease. 1. The right and wrong test, and the substantial capacity test. Different states use different tests. Most commonly used is the right and wrong test and the substantial capacity test. Those who do use the insanity plea and clinically pass can cause a jury to come to a verdict of not guilty by reason of insanity. In the 1993 Lorena Bobbitt case, Lorena Bobbitt was charged with malicious wounding. She testified to repeated rapes, beatings, and sodomizing by her husband. She testified that her husband had come home drunk, forced himself on her. She claimed her mind went blank, and later realized that she had sexually mutilated her husband by cutting off his reproductive organs and threw him in a field. The Lorena Bobbitt case did conclude with a verdict of not guilty by reason of insanity. With that being said, there are basically two groups of people that are incapable of committing crimes. One being children under 7, due to not yet reaching the age of reason. 2 being a person found to be insane or mentally diseased or defective under the test used in the state in which they are being charged. There have been many cases where defendants have faked insanity, some getting away with it and others don't. A couple cases that did not get away with it included the U.S. versus Carter, who had fooled the U.S. attorney, in which the doctors later determined that Carter was without disorder. Then the U.S. versus Prince, where the defendant was convicted of bank robbery and unlawful use of a firearm during the robbery, and later admitted he had acted out the following conduct in the courtroom. The defendant exposed himself and began to urinate in the courtroom. A few minutes later, the defendant was brought back into the courtroom while the trial judge was sternly warning as to his conduct. The defendant began to moan loudly, followed by more moans and screaming. 5 marshals were needed to remove him from the courtroom. Arguments were made that the conduct showed in the defendant was incompetent for trial. But federal courts of appeals affirmed that the defendant's conviction after he is admitted to acting out. Sentencing of those found insane or mentally diseased or defective include medical attention and detaining in a well-equipped mental institution. Once the institution has deemed the insane or mentally ill defendant cured or well enough to be released and safe for the public, and sentence has been completed, and sometimes can be later found that the defendant has been sane through the entire trial, and the defendant can never be retried for the same crime ever again due to double jeopardy. Knowing a little bit about this insanity defense, the question in the debate, insanity tests and faking insanity, I hope that the public can now ask themselves, if someone can never be retried for the same crime, should they be subject to double jeopardy, or in some cases be able to get away with the crimes that they got away with by simply fooling the courts?